Let me be direct with you right now. Last night, the Supreme Court of the United States issued a 6-3 emergency ruling. And if you woke up this morning without knowing about it, that tells you everything you need to know about what passes for news. In this country, this isn't some procedural footnote buried in legal journals. This is a fundamental reshaping of how power flows in America. Who gets to enforce what, where, and against whom? This is the Supreme Court's 6-3 emergency ruling on nationwide injunctions, and it may be the most consequential legal decision you've never properly heard explained. The highest court in the land just redrew the boundary lines between Washington and the states, and the ripple effects of that decision are going to crash into your life, whether you follow politics or not. I'm going to break this down for you. Not the sanitized, both sides version you'll get on cable news. The real version. The version that tells you what's at stake, who stands to gain, who stands to lose, and why this moment is one that law students will still be dissecting 50 years from now. Before we go any further, if you're someone who actually wants to understand what's happening to this country instead of just being told what to feel about it, hit that subscribe button right now. This channel exists to cut through the noise and give you the truth, unfiltered and unsponsored by anybody's political agenda. Subscribe, hit the bell, and stay with us because we are just getting started. Now, let's get into what actually happened. The Supreme Court, in a 6-3 decision, issued an emergency order that goes directly at one of the most powerful tools in federal litigation, the nationwide injunction. For years, this legal weapon has been used by federal judges to hit the pause button on entire state laws, not just for the people who filed a lawsuit, but for every single person in the country. Think about that for a second. One judge in one courtroom in one city could effectively freeze a law that affects 340 million Americans. That's not justice. That's judicial monarchy. And the Supreme Court just said enough. The core of this ruling is deceptively simple but seismic in its implications. The court held that lower federal courts do not have the authority to issue sweeping nationwide blocks on state laws when the dispute in front of them only involves specific plaintiffs. You sued because this law affects you. Fine. A court can protect you. But that same court cannot turn your lawsuit into a nationwide veto over the democratic decisions of an entire state government. The justices were clear. Relief must be tailored to the parties actually before the court, not weaponized into a blanket national policy override. And the fact that they did this as an emergency order, not after months of briefing and oral arguments, signals something important. The justices looked at what was happening in the lower courts and decided it couldn't wait. That urgency speaks volumes. To understand why this is so explosive, you have to understand how we got here. For the better part of the last 2 decades, both political parties have treated the federal court system like a legislative shortcut. Can't get your policy through Congress. Find a friendly judge, file a nationwide lawsuit, and watch a single courtroom decision do what 435 House members and 100 senators couldn't. Republicans did it to block Obama-era immigration and environmental rules. Democrats did it to block Trump's travel bans and deportation policies. And then Republicans did it again against Biden. The federal court system became an assembly line for nationwide injunctions, each one more sweeping than the last, each one pretending to be judicial relief while functioning as raw political power. What the Supreme Court recognized, and what the majority articulated with unusual directness, is that this practice has fundamentally corrupted the role of the federal judiciary. Courts are not supposed to make policy. Courts are not supposed to govern the entire country from a single bench. Courts are supposed to resolve disputes between specific parties about specific injuries. The moment a court starts issuing orders that apply to everyone, everywhere, it has stopped being a court and started being something much more dangerous, an unaccountable super legislature dressed in black robes. This ruling is the court's loudest warning yet that this era is ending, and the legal establishment on both sides is scrambling. Justice Neil Gorsuch's concurring opinion deserves special attention because it was not written with the careful, diplomatic language you usually see in Supreme Court decisions. Gorsuch was blunt. He said courts must return to the traditional limits of equitable relief and stop acting like, in his exact framing, many legislators Read that again. A sitting Supreme Court justice looked at what federal judges have been doing for years and called them out for legislating from the bench, not in theory, not as a hypothetical concern, but as a present, ongoing reality that the court is now moving to correct. The principle he invoked is old, and it's important. Equitable relief, meaning the kind of relief a court can grant to stop harm, has historically been limited to protecting the specific people who brought the case. You don't get to walk into a federal courthouse, file a lawsuit on behalf of your organization or your state, and walk out with an order that nullifies a law for the entire American population. That's not what courts are for. That's not what the Constitution authorized. And yet for years, that's exactly what was happening. And everyone in Washington either cheered or complained, depending purely on whose policy was being frozen. The hypocrisy was total. The principle was absent. And the Supreme Court finally looked at the wreckage and decided to step in. What Gorsuch opinion signals, and what the six-justice majority represents, is a court that is done pretending this was ever acceptable judicial behavior. The era of the universal injunction, at least in its most aggressive form, appears to be over. Now here's where I need you to stop thinking about this as an abstract legal debate and start thinking about your actual life, because this ruling touches nearly every major policy fight happening in America right now, in 2026, and the consequences are going to be felt in ways most people aren't prepared for. Start with immigration. For years, federal courts have been used to freeze enforcement actions and state-level immigration laws. With nationwide injunctions, under this new framework, a state that passes its own immigration enforcement law can no longer be stopped cold by a single federal judge's blanket order. Relief would be limited to the specific plaintiffs. That means some states enforce, others don't, and the patchwork becomes real. Gun regulations? Same story. If a state passes a firearm law that gets challenged in federal court, the injunction blocking it now has to be narrowly tailored. It cannot freeze the law nationwide. Environmental rules, which have been fought over in federal courts for a generation, are now subject to the same constraint. Election laws, potentially the most explosive category of all, are now harder to freeze with sweeping national orders, and healthcare policy, pandemic-related mandates, drug regulations, all of it now gets litigated in a narrower, more targeted way. And what this means for ordinary Americans is a legal landscape that is messier, more fragmented, and more dependent on which state you live in. It means the law you live under might be meaningfully different from the law your cousin across a state line lives under. That's always been somewhat true in America, but this ruling accelerates it. And whether that's a good thing or a catastrophic thing depends entirely on whether your state government is trustworthy. And that's a question you better start asking loudly, because the federal safety net just got significantly smaller. The political fallout from this ruling was immediate, and it was telling. The White House and the Department of Justice put out carefully worded statements saying they were reviewing the court's order. Let me translate that for you, because Washington speak requires translation. We are reviewing the order means we know this is bad for us. We don't know exactly how bad yet, and we are buying time before we have to explain to the public what we just lost. Inside the DOJ, career attorneys are privately calling this a legal earthquake, and that description is accurate. Because the DOJ has relied heavily on nationwide injunctions as an enforcement tool, using federal courts to block state laws it disagreed with, and now that tool has been dramatically weakened. The states, meanwhile, were not waiting for anyone's permission to move. Within hours of the ruling, attorneys general from multiple states had already filed supplemental briefs in ongoing cases, citing the Supreme Court's emergency order as direct support for their positions against federal overreach. The speed of that response tells you these state legal teams were ready, they saw this coming, or something like it. And they had their legal arguments prepared. In one of those filings, state attorneys argued explicitly that the Supreme Court had reaffirmed the right of states to defend their sovereignty without being subjected to blanket injunctions from unelected federal judges. That language, unelected judges, is doing a lot of work. It's a direct appeal to democratic legitimacy. And in the current political environment, where public trust in institutions is at historic lows, that argument lands hard. I want to be precise about something here because this story gets distorted almost immediately along partisan lines, and I refuse to let that happen. This ruling is not a Republican victory over Democrats. It is not a conservative court sticking it to the left. Yes, the 6 justices in the majority were appointed by Republican presidents. Yes, the 3 dissenters, including Justice Sotomayor, were appointed by Democrats. But the practice of using nationwide injunctions to freeze policies you disagree with has been used aggressively by both parties for 20 years. Republicans cheered when Trump-era policies blocked by Obama-appointed judges. Democrats cheered when Biden policies were restored by Clinton-appointed judges. The weapon was politically neutral. It was used by whoever was clever enough to find the right courthouse and the right judge. What the Supreme Court just did is take that weapon off the table for everyone. And that means the fights that used to get resolved in courtrooms now have to go back to the places they were always supposed to be resolved: legislatures, election campaigns, and the democratic process itself. If you want a national policy, pass it through Congress. If you want to change how a state operates, win elections in that state. You cannot outsource your political failures to a federal judge and expect the Supreme Court to look the other way indefinitely. And now, as of this ruling, you cannot. This is exactly the right moment to pause and make sure you're part of this conversation because it's going to keep developing and the stakes are going to keep rising. Subscribe to this channel right now if you haven't already. We cover the stories that actually matter, not the outrage of the day, not the political theater, but the legal and institutional shifts that reshape your life in ways the mainstream press either can't or won't explain. Hit subscribe. Drop a comment below telling me what part of this ruling concerns you most, and share this video with someone who needs to understand what just happened. Your engagement is what keeps independent journalism alive. Now let's zoom out and look at the bigger picture, because this ruling did not happen in a vacuum. The Supreme Court has been signaling its direction on this issue for years, and if you've been paying attention, this emergency order is not a surprise. It's the logical endpoint of a clear trajectory. The court referenced its earlier decision in Labrador versus Poe, a case that placed similar constraints on lower courts. Use of injunctions, that case got some coverage, but not nearly enough, because the implications were already enormous. And what the court is building case by case is a comprehensive reassertion of the separation of powers and the idea that the 3 branches of government have distinct roles, that those roles have limits, and that when any branch exceeds those limits, the court has both the authority and the obligation to intervene. The target here is not just nationwide injunctions. The target is a broader pattern of judicial overreach in which federal courts have increasingly functioned as policy arbiters, stepping in to make decisions that the Constitution reserved for the elected branches. This pattern accelerated under pressure. As Congress became more dysfunctional, as partisan gridlock made legislation nearly impossible, the courts became the battleground of choice. And judges, some of them responded to that pressure by issuing sweeping, muscular orders that went far beyond what any traditional understanding of judicial power would support. The Supreme Court is now saying, in the clearest possible terms, and that era is over. Courts do not govern, courts adjudicate, and the difference between those two things is the difference between a republic and a judicial oligarchy. The dissenting justices raised legitimate concerns, and intellectual honesty requires acknowledging them even when you disagree with the conclusion. Justice Sotomayor and the other 2 dissenters warned that restricting nationwide injunctions could create chaotic, unequal enforcement across the country, where the same federal law is applied differently depending on your geography. They're not wrong that this creates complexity. They're not wrong that it creates inequity in some cases. If a federal law is unconstitutional, or if a federal agency is acting unlawfully, why should the remedy be available only to specific plaintiffs while everyone else continues to suffer under the illegal policy? That's a real question, and it doesn't have an easy answer. But the majority's response to that concern, implicit in the ruling itself, is that the solution to bad federal law is not judicial governance, it's political action. Pass better laws, elect better officials, hold agencies accountable through Congress. The solution to institutional failure is not to give courts unlimited power to fix it. Because courts are not equipped for that role and the Constitution does not authorize it, the dissent's concern is real, but the remedy they prefer, expansive judicial power to correct systemic problems, is precisely the kind of judicial overreach that creates its own, arguably worse, distortions of constitutional government. Here's what I keep coming back to, and I want you to sit with this for a moment. The people who are most upset about this ruling are the people who had learned to use federal courts as a substitute for political persuasion. And I understand why political persuasion is hard. Winning elections is hard. Building legislative coalitions is hard. Going to a single federal judge and getting a nationwide injunction is comparatively easy if you can find the right court in the right circuit with the right precedents. That ease was always the problem. Democracy is supposed to be hard. Governance is supposed to require consensus building, compromise, and the difficult work of persuading your fellow citizens. When courts became a shortcut around all of that, they didn't strengthen democracy. They weakened it. And they created a system where the side with better lawyers and better forum shopping skills could override the democratic choices of entire state populations without ever having to win a single vote. That's not accountability. That's not self-government. That's power exercised by whoever knows how to navigate the legal system most effectively. And the people with the worst access to that system, working class Americans, rural communities, people without lobbyists and law firms on retainer, have always been the ones who paid the price when power was exercised that way. What happens next is the question everyone in Washington is asking right now. And the answer is complicated, because this was an emergency order, not a full merits decision after complete briefing and oral argument. It does not definitively close every question. It sets a precedent, a powerful, urgent one that lower courts are now obligated to follow, but it invites further litigation. The federal government will almost certainly test the limits of this ruling in other cases, arguing that certain circumstances, national emergencies, civil rights violations, constitutional crises still justify broader relief. Some lower court judges will push back, will try to find exceptions, will look for ways to preserve some version of nationwide injunctive power. The Supreme Court will have to respond to those challenges, and each response will further define the new legal landscape. In the meantime, the immediate effect is that dozens of ongoing cases involving immigration, guns, environmental regulations, and election laws are going to be revisited. Injunctions that are currently in place may be narrowed. States that have been blocked from enforcing their own laws may soon be free to proceed. And the federal government's ability to use litigation as a policy enforcement tool to go to court and free state laws it disagrees with has been significantly curtailed. This is going to get messy. It's going to get contested, and there will be moments when the messiness feels like crisis because the legal system doesn't absorb seismic changes quietly. But here's the truth that gets lost in all of this. The messiness is democracy working. A clean, efficient system where one judge can resolve everything for everyone might feel simpler, but it is not self-government. It is managed government, managed by whoever controls the courts. And what the Supreme Court is pushing us back toward, imperfect as it is, difficult as it is a system where policy fights and have to be won through the democratic process, through elections, through legislation, through the hard, unglamorous work of building political majorities and convincing your neighbors that your vision of the country is worth fighting for. That is harder than filing a lawsuit. It is enormously harder, but it is also the only path to durable change in a constitutional republic. Court victories are fragile. They can be reversed by other courts, limited by future rulings, undermined by non-enforcement. Political victories, laws passed by elected majorities, policies embedded in democratic consensus, are harder to undo because they reflect the will of the people who have to live under them. The Supreme Court just told America, if you want something to last, you have to earn it the hard way. And after decades of watching both parties try to shortcut their way to power through the federal courts, maybe that reminder is exactly what this country needed. The people this ruling will hurt most in the short term are the ones who are relying on federal court intervention to protect them from state governments that they believed were acting unjustly. And that concern is not dismissible. There are communities in this country, minority communities, immigrant communities, communities whose political power at the state level is limited, that have historically turned to federal courts for protection because the state political process was closed to them or hostile to them. The civil rights movement understood this. The federal courts were sometimes the only venue that would hear those communities' claims. That history is real and it casts a shadow over any ruling that limits federal judicial power. But the counter to that concern is not to preserve a system of nationwide injunctions that has been massively abused for political purposes. The counter is to do the harder work of rebuilding political power at the state level, of registering voters, of organizing communities, of running candidates, of making the state democratic process more responsive and more just. Federal court intervention was never meant to substitute for that work permanently. It was meant to be a backstop in extreme circumstances, not a routine tool for one side of the political spectrum to nullify the other's electoral victories. The Supreme Court's 6-3 emergency ruling on nationwide injunctions is not the end of the story. It is the beginning of a new chapter in the ongoing American argument about who gets to govern and how, and within what limits. It will be debated in law schools and congressional hearings and state legislatures for years. It will be tested in dozens of cases across every circuit in the country. It will produce winners and losers in the short term in ways that won't always map cleanly onto partisan expectations. But its core message, that courts are not legislatures, that judges do not govern nations, that power in a constitutional republic must be earned through democratic processes, is a message that should command respect across political lines. Even if you disagree with how the current court reached this conclusion, even if you're worried about what it means for the specific fights you care about, the principle is sound, and principles are what constitutional government runs on when everything else gets chaotic. So here's what I'm asking you to do. Don't just watch this. Don't just share this and move on. Start demanding from your elected representatives at the state level, at the federal level, that they do their jobs. If there are policies you believe in, fight for them in the legislature. If there are laws you think are unjust, challenge them through the political process. If your state government is failing you, organize and change it. The Supreme Court just closed one shortcut. The long road is still open. And democracy, real democracy, has always been a long road walked by people who refuse to stop. We are going to keep covering every development in this story as it unfolds, because this is the kind of ruling whose consequences take months and years to fully understand. The legal fights it triggers are going to reshape American governance in ways we are only beginning to see. Subscribe to this channel right now so you don't miss a single update. Hit the like button if this breakdown gave you something the mainstream media didn't. Drop your thoughts in the comments. I want to know what you think about this ruling. What scares you about it? What gives you hope? Share this with someone who deserves to understand what's actually happening. In this country, independent journalism lives or dies on whether people like you decide it's worth keeping alive. I believe it is. I believe you do too. Stay informed, stay engaged, and never stop asking the questions the people in power don't want you to ask.